Constitution and the rule of law. Definition of the Constitution. The term constitution comes from the French constituer, which means to form. The use of the term constitution in question is the formation of a state or compiling and declaring the rules of a state. The meaning of the Constitution in practice can be interpreted more broadly than the meaning of the Constitution. In political science, the Constitution is something broader, namely the whole of the regulations, both written and unwritten, which regulate in a binding manner the ways in which a government is organized in a society. Constitution is the basic principles and laws of a nation, state, or social group that determine the powers and duties of the government and guarantee certain rights to the people in it. Definition. In Latin, the word constitution is a combination of two words, namely cum and statua. Cum is a preposition which means together with, while statua means standing. On that basis, the word statua means to make something stand up or establish. The Oxford English Dictionary defines a constitution as a body of fundamental principles or established precedents according to which a state or organization is governed. The Collins Dictionary says a constitution consists of the fundamental principles on which a state is governed, especially when considered as embodying the rights of subjects. Constitutions protect democracy by separating state power into three arms. The legislature, parliament, the provincial legislatures and local councils, makes the laws and monitors the executive. The executive, the president, deputy president, and ministers, makes policy, proposes laws and implements laws passed by the legislature, and the judiciary tries cases and administers justice. Rule of law. Essentially, the doctrine of rule of law is the concept of a constitutional state, which means that the law holds the highest position in the administration of a constitutional state. The rule of law is a durable system of laws, institutions, norms, and community commitment that delivers four universal principles: accountability, just law, open government, and accessible and impartial justice. 1. Accountability. The government as well as private actors are accountable under the law. 2. Just law. The law is clear, publicized, and stable and is applied evenly. It ensures human rights as well as property, contract, and procedural rights. 3. Open government. The processes by which the law is adopted, administered, adjudicated, and enforced are accessible, fair, and efficient. 4. Accessible and impartial justice. Justice is delivered timely by competent, ethical, and independent representatives. The term was introduced by A.V. Dicey. He outlined three key elements of the rule of law, namely: 1. Supremacy of law. This aims to ensure that the law protects all members of society without any interference from any party by enforcing and placing the law in the highest position. In this regard, a person can only be subject to legal sanctions if they have committed a violation. 2. Equality before the law. Simply put, this means that every citizen has an equal standing before the law. 3. Due process of law. This element serves to guarantee citizens' rights to undergo legal proceedings according to applicable procedures, ensuring a fair, impartial, proper, and just legal process. The implementation of rule of law in Indonesia. As a country based on law, rechtsstaat, rather than power, marktstaat, Indonesia also applies the concept of rule of law as stated in Article 1 Paragraph 3, Article 27 Paragraph 1, and Article 28d Paragraph 1 of the 1945 Constitution. According to Jasmansyah Siddiqui, the content of these provisions indicates the fulfillment of the rule of law concept in Indonesia, which includes: 1. Recognition of the principle of supremacy of law and the Constitution. 2. Adherence to the principle of separation and limitation of powers. 3. Guarantees of human rights. 4. An independent and impartial judiciary that ensures equality before the law and justice for every individual, including protection against abuse of power by authorities. One of the manifestations of the rule of law in Indonesia can be seen from the implementation of laws and regulations as the foundation for the roles of state institutions and their administrative functions in Indonesia. The application of the rule of law is also reflected in the Pancasila legal system adopted by Indonesia. In this context, judges have the right to interpret and provide opinions beyond the provisions of written law when deciding a case, as law is viewed from two perspectives: formal and material. Conclusion. The Constitution serves as the fundamental legal framework of a state, outlining the structure of government, citizen rights, and the distribution of power. It ensures checks and balances while safeguarding human rights. The rule of law, introduced by M.Pd, emphasizes the supremacy of law, equality before the law, and fair legal processes. In Indonesia, the rule of law aligns with the Pancasila legal system and the 1945 Constitution, ensuring justice, accountability, and separation of powers. It highlights an impartial judiciary, adherence to legal principles, and protection against misuse of authority.